On February 24th, the Securities and Exchange Commission released significant updates to its enforcement manual, the first major revisions in nearly a decade. The most substantial changes overhaul the Wells process to increase transparency, fairness, and efficiency in enforcement investigations. The Wells process is the informal mechanism through which the Securities and Exchange Commission's enforcement staff notifies an individual or company that the staff intends to recommend the Commission file an enforcement action against that person or company. A Wells notice outlines potential violations, and recipients may submit a written Wells submission explaining their position before the Commission decides whether to authorize enforcement. Although originally intended to promote fairness, the Wells process had become criticized as opaque. Wells notices frequently lacked detail, leaving recipients with an incomplete understanding of the evidence or theories behind potential charges. The Commission's update directly addresses these transparency concerns. The updated Wells procedures require enforcement staff to disclose salient evidence to recipients. This gives respondents clearer visibility into the factual basis for any recommended enforcement action. A Wells notice may now only be issued with director-level approval, adding senior oversight before any enforcement recommendation proceeds. Historically, it was up to the staff to decide how long to give a recipient of a Wells notice to respond to the proposed action, in what is known as a Wells submission, often giving as little as 2 weeks. Recipients now have 4 weeks to prepare their responses, allowing more time to analyze evidence and craft effective arguments. All Wells submissions must now be routed directly to the commissioners, ensuring that respondents' arguments reach the officials who will ultimately decide whether to authorize enforcement action. Post-Wells notice meetings must occur promptly and must include senior leadership, at the associate director level or higher. This enhances the quality and timing of discussions after submissions are filed. In addition to changes to the Wells process, the Commission made other important changes to its enforcement processes. For instance, as part of settlement negotiations that often occur during the Wells process, parties may now submit waiver requests in tandem with settlement offers. These waivers are essential because certain settlements can automatically trigger, among other things, disqualifications that prevent individuals or firms from participating in important securities activities. Under the updated approach, the Commission considers these waiver requests alongside the settlement itself, helping ensure that parties understand, before finalizing an agreement, whether they will remain eligible to serve in roles such as associated persons of regulated entities or issuers relying on exemptions. For respondents, the revised Wells process brings 4 key advantages. First, greater transparency into the evidence gives respondents a clearer picture of the case. Second, doubling the response period allows more time to prepare thoughtful, fact-driven submissions. Third, guaranteed commissioner review ensures arguments reach the ultimate decision-makers. And finally, prompt post-Wells meetings with senior leadership create a more meaningful opportunity to clarify issues before charges are finalized. Together, these updates make the process fairer, more predictable, and more strategically impactful for respondents. By modernizing the Wells process, the Securities and Exchange Commission has strengthened transparency and fairness at a critical stage of enforcement. Understanding these changes helps respondents navigate investigations more effectively and advocate with greater impact.